Right now on the Daily Debrief, opening statements in 2 trials. First,
her wrists were bound together behind her.
the case of a Florida personal assistant duct taped and stabbed. Second, the case of a Texas child found dead in a culvert. Her father, on trial, says he accepts responsibility.
He thinks about that day every single minute of his life.
So, why did he tell 2 versions of her death to the police? The Daily Debrief recaps the day in court. It's Monday, June 24th.
Welcome to the Debrief, everybody. Aaron Keller along with Michael Bryan. Good to see you.
Nice to see you.
Our other guests will be joining us remotely in just a moment. Opening statements in 2 new trials today, as you just heard. The first in Florida. Defendant Scott Nelson faces charges he kidnapped and killed 56-year-old Jennifer Fulford. The victim was a personal assistant and nanny to a wealthy man, and the defendant is accused of taking her from the home where she worked and dumping her body in a wooded area. The defense has argued that Nelson's mental health status will make it hard for him to testify if he so chooses. The state began its case with a graphic description of how the victim was found.
Her ankles were bound together with duct tape. Her wrists were bound together behind her with a zip tie. When they turned her over to transport her to the medical examiner's office, they saw that she had duct tape wrapped around her entire head. It covered her face from her chin to her eyebrows. She would not have been able to see. More importantly, she would not have been able to breathe. She had 2 superficial stab wounds to her back. They were not deep. But she had 5 penetrating stab wounds to her chest, 2 of which directly pierced her heart. A knife was located in the field not far from her body. It had a rather unique handle. It had a blade capable of causing stab wounds to her body. And most importantly, it had her DNA on it.
The defense gave what some lawyers call a non-opening opening. It was all theory and no fact.
In Washington, D.C., there's a building, and it's called the National Archives. If you go into the National Archives, you'll notice that there are a bunch of documents that are really important in our nation's history. Declaration of Independence, the Magna Carta. You'll also see the Bill of Rights. And the Bill of Rights, if you looked at it, you'll notice that it's kind of old and fragile looking, and that the writing's faded. But what's interesting is while this document is old and faded, that the principles that were espoused in that document stand strong today, particularly the right to be tried by a fair and impartial jury. And the only way that that's done is to go through the thought and the principle that every person is presumed innocent until and unless the state proves that beyond all reasonable doubt.
One of the first witnesses for the state was a school employee who said the victim did not pick up the son she nannied at the scheduled time, despite evidence that the victim left in a panic, thinking the child was involved in an emergency.
Tell us exactly how aftercare works. Where would you have been that time of day?
Aftercare is in the cafeteria, and the kids come to me. The regular kids just automatically come. Ones that are not picked up or parents have said they need to be drop-ins that day are brought over.
Okay. So was Oliver a regular to you that day?
No.
He wasn't supposed to come to you that day?
No.
Did he ultimately come to you that day?
Yes, he did.
And about what time would he have gotten to you?
3:45 about.
So he was supposed to go home in the carpool. Mm-hmm. Nobody came to pick him up, so they brought him to you.
Yes.
At some point, did somebody at Lake Highland contact Oliver's parents because he had not been picked up?
Yes, they did.
And did his father come to pick him up from school that day?
Yes, he did.
And did his father, Reed Berman, sign him out of school that day?
Yes, that's our policy.
And do you know what time he was signed out?
4:30 something.
The man who employed the victim described his last interactions with her.
Now, at some point, she and Oliver left the house.
Correct.
Do you recall if you saw them before they left the house for her to take him to school?
He would usually, after breakfast or when he finished getting ready, he would come in my room and give me a hug goodbye.
Okay. And so Jennifer was the one who took him to school that day.
Yes.
After Jennifer dropped him off at school, did she come back to your house?
Yes.
And did you see her before you left for work?
Yes.
What time about did you leave for work that morning?
It was around 8:45 because I had a 9 o'clock breakfast appointment.
Now, after you left for work that morning, did you ever see Jennifer Fulford again?
I did not.
Did you ever?
One of the first officers on the stand described tracing the victim's last known steps in an attempt to find her or her car. All he found was the purse she left behind at the home where she worked.
I went to areas that she may have been at. I obtained information from Mr. Berman, and I eventually spoke to her husband, Mr. Fulford, that gave me information where she may have been that day. So I went and checked and just tried to find her vehicle, see if it was parked somewhere.
All right. Would one of those locations have been a dentist's office?
Yes,
Were you able to locate the vehicle at that dental office?
I did not.
You said that you had spoken to Mr. Fulford,
Yes,
Jennifer Fulford's husband.
yes.
All right. Was that in person or over the phone, at least initially?
Initially, it was over the phone.
All right. Did you learn from him whether or not there were ATM transactions that had taken place?
I did.
Did you go by the ATM to determine whether or not the vehicle was in that area?
Yes.
Did you find it?
No.
Victim Jennifer Fulford's husband also described his final interactions with her.
Who left the house first?
She left first,
Do you know about what time she left?
around 6.
Anything out of the ordinary with her when she left that day?
No.
Sir, did you ever see her again after she left your house that morning?
I did not.
What did you do upon learning that information that your wife might be missing?
I tried to call her.
Any luck contacting her?
No.
Okay. And about how long were the law enforcement officers at your house, the ones that first came from the Altamont Springs Police Department?
30 minutes.
So after they left, what did you do?
I called her friends, I called her family, and tried to see if anybody had heard from her.
Okay. Tell us some of the people that you called.
I called her sisters, I called her children, Austin, Hannah.
Do they have children of their own?
Austin, at the time, had one and was expecting one
When was his second baby born?
that same day.
Austin's child was born on September 27th, 2017.
Yes.
And when you talked to Austin, had he heard from his mom after his baby was born?
No.
A friend then testified about that frantic call she shared with the victim when the victim apparently believed the child for whom she cared was sick at school.
You said that you had the 3 missed calls, the 1 voicemail, and then you called Miss Fulford.
Yes, I called her.
And when you called her, did she answer?
No,
Did she subsequently call you shortly after you called her when she didn't answer?
yes, very soon after.
Okay? Can you please tell the jury what was her demeanor like when she called you?
She was very, very upset. She had a very panic in her voice.
Now, please tell us what it is she said to you.
She said that Oliver was sick and that she had to go to the school and pick him up.
Okay? Did she say anything else?
She told me not to come.
Okay.
Attorneys Joseph Tully, Ashley Wilcott, and Michael Bryant are with us tonight. So Joseph, security cameras at the home where this woman was working were not working for months leading up to this. Does that cripple the state's case?
I don't think so. I think they have pretty good evidence in this case. And I think the defense is going to have a lot out for them, especially given the emotional nature of the facts of this case.
Yeah, I mean, this is just brutal. We're talking about stab wounds straight to the heart, the duct tape. It's just gruesome. So, Judge Wilcott, I want to know more about any relationship whatsoever between this defendant and this victim. That's a big question mark right now. Was this literally a random crime, in your opinion?
I have to tell you, it's so infrequent to see a truly random crime. More often than not, there's some type of relationship, even if it's only cursory. It remains to be seen, but I suspect there's been some crossing of the paths. I don't believe it to be completely random.
Yeah, I agree with that as well. And look, Michael Bryant, we've got this case on the calendar for 2 to 3 weeks. Maybe we'll hear more about this phone call that we just listened to preliminary testimony about, getting the victim to go pick up the child who it turns out was not sick. If this was a random crime, it seems like there's evidence this woman was targeted in some kind of sick way. Do you buy that theory?
Yeah, that's an interesting ruse, if that's what it was, to somehow isolate her. I also thought, well, maybe this guy, the employer, he is a real estate investor, had some money, had some valuable things in his house. Maybe, in fact, this was a defendant just doing a burglary that went horribly wrong because the victim was home. I don't know. I just don't know yet.
One possible theory, exactly. And Joseph, I'll go back to you here. This trial is moving along at a lightning fast speed. The attorneys not wasting any time with the irrelevant. Look at the number of witnesses we had just on day one.
Certainly, yeah. This is a really quick-paced trial, and I think it benefits both sides. So they're both, the prosecution and the defense are using that to their advantage. The prosecution is getting right to the point that they want to get to, but yet the defense is sort of staying honed in on the issues too of what they can defend against, what they can't defend against.
That's true, but Judge Wilcott, look, we had this non-opening opening. Did jurors expect a little bit more of a theory from the defense? I realize they don't have to present one, but does it really do anything to get up there and start talking about the Declaration of Independence and the Constitution and the archives in Washington, D.C.?
From my perspective, no. I think, unfortunately, that can bore a jury. It's something that they don't feel like, what does that have to do? They do feel like, what does that have to do with this case and their theory and their defense? So I think the defense, strike one in terms of the opening, may have lost the jury.
I fear that as well. We will be back to the panel at the end of the broadcast. Today, marking 1 month since a Connecticut woman disappeared, and strange new details have come to light. Estranged husband Fotis Doulos and his girlfriend Michelle Troconis are accused of tampering with evidence in the case of Jennifer Doulos. Police say surveillance cameras in Hartford, an hour away from where Fotis Doulos lives, caught him throwing away bags of garbage the day Jennifer disappeared. A lawyer for Fotis Doulos is looking into a so-called very dark 500-plus page novel Jennifer wrote, plus $14,000 in medical tests she incurred just before she disappeared. That lawyer for Fotis Doulos said, "The Gone Girl hypothesis is very much on our mind." Still ahead tonight on The Debrief, deliberations coming to an end in a California death penalty case that pushed into a second week. Plus, a Texas child is dead. Her father claims he accepts at least some responsibility and promises to tell his side of the story on the witness stand. That case is also after the break. A verdict to report involving the fate of a California man convicted of killing a family of 4. Jurors have reached a decision as to whether Chase Merritt should be sent to prison for life or be put to death. The same jury already convicted Merritt of murdering business associate Joseph McStay and McStay's family. This penalty phase of the case took 4.5 hours of deliberation. The verdict will be read in about an hour and a half from now, 3:45 Pacific time, 6:45 on the East Coast. If you can't wait for tomorrow's edition of the Debrief, you can watch Twitter for updates from the Law and Crime Network. And now to the second trial we are following here on the Debrief. Texas defendant Wesley Mathews, who did face a murder charge, entered a so-called slow plea late last week to a lesser offense of injury to a child by omission. The slow plea is an admission of guilt, but the jury must select a punishment. The victim was 3-year-old Sharon Mathews. The defendant said she disappeared in October 2017 after he left her outside to discipline her. He also said that she died while choking on milk and that he hid her body in a culvert. So let's begin our review of this case with the state's opening statement.
A sweet, adorable, fun-loving little girl. She was born in India. She was abandoned at a very early age and lived in an orphanage in India until July of 2016, about the time she was 2 years old. At that point, she was adopted by the defendant and his wife and brought to live with them in Richardson. Sharon had some medical issues. Sharon had some developmental delays as well. And this afternoon, you're going to get to hear from a few of the therapists who worked with Sharon. You're going to hear from Nikki Darafone. Nikki was Sharon's speech therapist. She worked with her in 2 areas. One, language development. And again, just like the physical therapy, Sharon worked hard at it, met her goals, was discharged from speech therapy. Nikki also worked with Sharon in the area of feeding therapy. Sharon had some difficulties. She would pocket food in her cheek. She had aversion to certain types of food. Now, what Nikki will tell you, though, is Sharon didn't have anything mechanically wrong with her ability to swallow or the structure of her mouth or anything like that. She'll talk to you about food aversions and pocketing food and what that means and what she did to work with Sharon in that regard as well. And Sharon was improving. She was getting better. But unfortunately, after those witnesses, the rest of today and the bulk of tomorrow is going to be centered around the death of Sharon.
The defendant's tactic is to admit at least some culpability and to hope for leniency.
You're going to hear from Mr. Mathews. You're going to hear from him sitting right here. He's going to look at you and he's going to tell you exactly what took place. The lies, the poor decisions that he made, and the enormous regret that he has. But you will also know that he has accepted responsibility for what he has done and what he was guilty for. Injury to a child by omission, by not calling 911. He is going to tell you how he thinks about that day, every single minute of his life, and how he wishes he would have broken through his wife's room where she was asleep and woken her up for help, but he tried to do it himself. And how he feels like a failure for not being able to save this daughter that he chose, he adopted, he knew.
A speech therapist who worked with the victim said the little girl never had trouble swallowing during her sessions. This was an attempt to blast one of the defendant's stories about what happened.
When I referenced back to my notes, I never notated that I saw her ever choking on anything. I do recall occasionally when she did not like something, she might have gagged on it a little bit initially, but never choking.
Was there anything through your expertise that you could see that was wrong with her ability to swallow or anything with the mechanisms in her mouth or anything like that? Or more like you said, if she didn't like a food, she would gag on it, spit it out. We'll talk about pocketing in a minute, things like that.
Mm-hmm. So as part of our evaluation, we do take a closer look at the child's oral structures, looking at their teeth, their tongue, their mouth, and how they're able to maneuver that for food and drinking, for chewing, biting, for swallowing. Overall, she demonstrated functional and age-appropriate skills. You know, in regards to her chewing, with some foods she was able to chew great, and with other foods, preferably ones that were not preferred, she didn't always chew those appropriately.
Okay, so returning now tonight are Judge Ashley Wilcott, attorneys Michael Bryant and Joseph Tully. So Ashley, this girl's internal organs had decomposed so badly that an internal autopsy was impossible. So is it possible we might never fully know the truth here?
Absolutely, and Aaron, that's what discourages me so much about cases like this. It is an innocent victim, a child. We may not ever know all of the truth and what happened to this child, but here's what I can tell you definitively. No, hands down, abused, killed, in my mind, period.
That's what you think happened. I mean, what's going on with this discussion about chewing milk? Like, you don't chew milk. Like, nothing makes sense about that to me. But anyway, Joseph, what do we make of this tactic legally of admitting guilt to a lesser charge and then agreeing to testify? That cross-examination is going to be brutal.
I think the defense attorney did the best that they possibly could with this situation. On one hand, the prosecution, though, doesn't give up too much. The defendant still is facing life. So from the prosecution's point of view or from the public's point of view, it doesn't really matter if he's guilty, if he, what he's in for. It's really what the punishment is about. But on the other hand, it was a good tactic for the defense. I think they're doing the best they possibly can.
Yeah, I mean, this has got a broad range here. We could be probation all the way up to life in prison. So even though it's not a murder charge, okay, look, the punishment is so similar. What difference does it make in the long run? Michael Bryant, here's how I think it ends. The jury sits there and says, give me a break, defendant. You told multiple versions of this story. That is not accepting responsibility. So don't sit here and try to claim you are accepting responsibility and therefore harsh punishment. Do you think I'm wrong or do you think I'm right?
I think you're on the right track. I think this defendant is either a genius monster or just the dumb luckiest guy ever, because the fact that he hid that body for a couple of weeks or more led to the inability to determine actual cause of death. And that meant the prosecutor couldn't even seek the death penalty initially, let alone this kind of hand slap of a plea that they've given this guy. So hopefully the jury will see through all of that and give him the max.
Okay, so if you're a legislator in Texas, you are pointing to the soliloquy here of Michael Bryant to say this is exactly why we need these huge sentencing ranges on crimes like this. Judge Wilcott, we've just got a couple of seconds.
Listen, the thing that bothers me is when you do a lesser offense, you have such a wide range. That's trouble. It just gives so much to the jury. They could do anything, and I think that's hard for a jury to have to do.
Well, they're going to have to come to some kind of agreement here, and let's hope that they do, because we don't want a hung jury. We hate those. Look, panel, thanks a lot for joining us tonight, and thanks for those of you watching along. Our live trial coverage resumes at 9 o'clock in the morning. The Debrief back tomorrow at 5.